The topic we will address in this lesson concerns the current regulatory framework on civil liability for damage caused by artificial intelligence systems. First of all, it should be noted that civil liability, as outlined in the previous lesson, can be contractual or non-contractual. Contractual liability presupposes the existence of a contractual relationship and arises from a breach of the obligations established in the contract. Non-contractual liability, on the other hand, derives from the general principle of neminem ledere, according to which care must be taken not to cause unjust damage to others, regardless of the existence of a contract between the injuring party and the injured party. Anyone who causes unjust damage to others, whether intentionally or through negligence, is liable for it and is therefore required to compensate the injured party. The nature of artificial intelligence poses complex challenges in the attribution of liability, essentially with regards to two aspects. The first aspect concerns the constant development of artificial intelligence systems, which are characterized by increasing decision-making autonomy. This autonomy makes such systems sometimes unpredictable and, as a result, complicates the attribution of liability. The second aspect concerns the multiplicity of actors involved, which makes it difficult to identify the responsible party in the event of damage. In the context of contracts, and therefore contractual liability, it is the parties who decide how to allocate mutual responsibilities and how to regulate compensation for damages. In cases of non-contractual liability, on the other hand, the victim may not know who to turn to in order to obtain compensation for their damage. This is particularly true in the case of artificial intelligence, since there can be many different parties involved in developing the system, and there is no relevant regulatory framework. To address this complexity, several legislative proposals have been put forward at the European level over time. Initially, a model based on so-called strict liability was proposed, which attributed liability without the need to prove fault or negligence on the part of the responsible party, with the aim of protecting the victim more effectively. In particular, for high-risk artificial intelligence systems, the legislation on liability for dangerous activities would apply. However, this approach proved to be unsatisfactory. On the one hand, it risked slowing down innovation and investment by AI technology providers. On the other hand, it paradoxically complicated the position of the injured party, who often found it difficult to prove the extent of damage and establish a causal link. Consequently, the European legislator has abandoned the model of strict liability, moving towards a more balanced regulatory system capable of ensuring effective protection for victims without hindering technological developments. This is the context for the proposal for a directive of the European Parliament and of the Council on non-contractual liability, which provided for a presumption of a causal link between the harmful output produced by the AI system and the fault of the potentially liable party, specifically identified as the provider or the operator who implemented the system, i.e. the deployer. However, this proposal was not accepted, and at present there is still no clear and comprehensive regulatory framework specifically governing civil liability for damage caused by AI, leaving important questions of interpretation and application open. Legislative intervention on this issue is therefore absolutely necessary in order to establish a liability regime that, on the one hand, protects potentially injured parties and, on the other, does not hinder innovation and development in the field of AI.